joining Seyfarth's webinar, Commercial Litigation Outlook, Post-Pandemic Trends and Emerging Challenges in 2021. All participants are in listen-only mode. You are encouraged to submit questions through the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. If we run out of time, one of our panelists will follow up directly to answer your question. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Sean Wood. Sean, you may.
Thank you, Danielle. Welcome, everyone. My name is Sean Wood, and I chair the Commercial Litigation Practice Group at Seyfarth Shaw, along with my co-chair, Rebecca Woods. We're thrilled to have such a tremendous turnout for our Commercial Litigation Outlook 2021 program today. As we emerge from the pandemic at this stage, with more and more courts reopening, and as we recently hit the 100-day mark of a new administration, we've got a lot of ground to cover, both in terms of what we're seeing and what we anticipate seeing on the business litigation front. Toward that end, we have a full slate of speakers, and to give you a quick roadmap in terms of what we'll be covering today, we're going to be starting with Brandon Bigelow, who will be addressing key trends in antitrust and franchise litigation, followed by Paul Jovanik, who will be speaking on biometric privacy issues. Next, Tanya Esposito will be speaking to the increase in regulatory and enforcement activity in the area of consumer financial services. Scott Carlson and Jason Priebe will be addressing the rapid changes in cybersecurity, data protection laws, and e-discovery, followed by Jesse Coleman, who will be tackling the surge in healthcare litigation and false claims investigations. Elizabeth Schriero and Mark Johnson will be addressing the evolving landscape of real estate litigation, particularly in the wake of COVID-19. And finally, Chris Robertson will be discussing the balance courts are striking between virtual and live trials and hearings as we head into the second half of 2021. So to kick things off, we'll begin with the co-chair of our Antitrust and Competition Practice Group, Brandon Bigelow.
Thanks, Sean. On antitrust, it has now been, next slide please, Danielle. On antitrust, it has now been 5 years since the DOJ issued its HR guidance warning companies that they should not be talking to their competitors about agreements to not poach or hire or solicit each other's employees if those were what were referred to as naked agreements. That is, agreements that were not necessary and ancillary to some legitimate collaboration. The DOJ issued that warning 5 years ago and said that it was going to begin enforcing the Sherman Act criminally, and those criminal prosecutions have begun. They began in 2020, and they have continued and continued to file in early 2021, and we expect to see criminal prosecutions going forward where competitors engage in no poach or no solicitation agreements that are naked. That is, again, if they are not ancillary to some legitimate collaboration between those companies. We've had our 5 years of warning. The DOJ did everything it could civilly. It's now proceeding criminally. In the next year, we're seeing, of course, the DOJ has now filed its litigation against Facebook and others, and we're seeing a lot more skepticism about transactions involving tech companies. And so you should anticipate increased enforcement on the Hart-Scott-Rodino front. And then finally, you probably out there in the world are seeing class action settlements coming through, including the recent Blue Cross Blue Shield class action settlement. We're going to continue to see settlements of large antitrust litigation and payouts on those claims. Next slide, please. And on the automotive franchise, and more broadly speaking, in the automotive sector, we saw, due to the COVID pandemic, a massive shift to online retailing as it became impossible or unlikely that folks would go into dealerships during the pandemic. And frankly, people liked it. And so it's going to continue that way. Cars are being sold online more and more. Dealers and manufacturers are having to respond to that shift. At the same time that manufacturers are responding to the emergence of electric vehicle-only manufacturers. These are manufacturers who did not make internal combustion engines and therefore didn't set up a dealer network under the traditional model, and therefore aren't necessarily covered by state dealer laws that are very specific to manufacturer-dealer relations. And those electric vehicle manufacturers enjoy a tremendous advantage over traditional manufacturers because they are not subject to those state regulatory regimes. You're going to continue to see that tension between traditional state regulation and the electric vehicle manufacturers who are not subject to that traditional regulation. Finally, on the much larger front, in California, California has thrown a major monkey wrench generally into the franchise model with the passage of AB 5, which was effectively, I think, meant to be a response to some abuses of the franchise model where folks were being treated as franchises when in fact they were employees. Rather than simply outlaw that conduct in the narrow areas where that conduct was occurring, the California legislature passed AB 5 and effectively banished the independent contractor relationship unless it was allowed under California law, and then created a carve-out for many, many, many different kinds of business. That has not worked out so well, and frankly, it has led to a great deal of litigation and makes the franchise model somewhat perilous. That will play out throughout California courts in 2021. Thanks, Sean.
Thank you, Brandon. Next up, from our Workplace Privacy and Biometrics group, Paul Yovanik.
Great, thank you, Sean, and thank you everybody for joining us today. I want to take a few minutes today to discuss biometric privacy, where we're at currently, and what trends we see moving forward. I'll start by discussing biometrics generally, and then touching on the Illinois Biometric Information Privacy Act, since many of the trends we are seeing now originate from Illinois statute. So in general, biometric information is not just fingerprints as though many would suspect. Biometric information includes retinal scans, shape of the hand or face, and even the sound of your voice. We often see biometric scanners linked to time clocks to prevent buddy punching. That's a term that refers to employees clocking in for other employees. But we're now seeing the use of biometric scanners in various other ways, such as to facilitate consumer transactions and for access to secure areas. Turning to the next slide, there are only 3 states with standalone biometric privacy laws currently, and that's Illinois, Washington, and Texas. And Illinois is the only state currently that has a private right of action. As we turn to the next slide to briefly discuss the Illinois Biometric Information Privacy Act, you'll see why it's been particularly attractive to the plaintiff's bar. The Illinois Biometric Information Privacy Act was enacted in 2008, and it was motivated by the bankruptcy of a company called Pay by Touch, which at the time was the largest fingerprint scan system in Illinois. And while the statute has been around for over a decade, it has really gained momentum in 2015 due in part to greater affordability for biometric scanners and also due to its increased uses beyond time clocks. And so as you see, the Illinois Biometric Information Privacy Act regulates against the collection, the capture, the storage of biometric information and identifiers, such as those we previously discussed, and requires a publicly available written policy and user consent for all private entities. The statute has been particularly appealing to the plaintiff's bar due to its statutory damages, most importantly, the attorney's fee provision. As such, there have been over 1,000 Illinois Biometric and Information Privacy Act cases filed since 2015 through 2020. And since the statute went largely untested until 2015, courts have still been interpreting the statute, and there are a few matters currently on appeal that may alter the landscape of these biometric lawsuits. So turning to the next slide, there are 3 key issues on appeal right now. One before the 7th Circuit is the Cochran case, and that's going to determine whether or not a plaintiff can recover statutory damages each time their biometric information is scanned, or whether they may only recover upon the first scan and collection of biometric information. So as you can imagine, plaintiffs have been taking the position that they are entitled to damages each time that their biometric identifiers are scanned, such as their hand. So we can take it in the employment context. So when an employee clocks in the morning, there's one scan, punches out for lunch, punches back in, and then clocks out at the end of the day. I mean, there's 4 scans in one day. So while that might seem like an unrealistic approach to the statute, since it hasn't been interpreted, the Seventh Circuit will be tasked with that. The Timms case will determine whether or not the 1, 2, or 5-year statute of limitation applies to biometric information privacy claims because the statute was just silent on that issue. And as we turn to the Symphony case, that'll determine whether the Illinois Workers' Compensation Act preempts biometric claims since it is arguably a workplace injury in the employment context. So turning to the next slide, as I said earlier, we wanted to discuss the Illinois Biometric and Information Privacy Act because we are starting to see copycat legislation across the country. In January of 2021 alone, we saw both New York and Maryland introduce their own standalone biometric privacy laws. New York's proposed legislation is entirely identical to the Illinois statute. So if it's passed, it is likely that we see that the statute will be subject to the interpretations on appeal that we just discussed. Maryland's statute is substantially similar, but it differs in some respects. For example, the proposed legislation broadens the definition of biometric identifiers and biometric information compared to what we've seen so far. And in the employment context, the proposed legislation clarifies that retention and destruction policies need not be made publicly available if used for internal company operations. That is one issue that's been key in legislation or litigation in Illinois. So finally, on the last slide, as businesses start to open back up following the peak of the pandemic, we've seen an increasing amount of litigation and client inquiries regarding the use of thermal temperature scanning. Oftentimes, businesses have been wanting to use these thermal temperature scanners to check customer and employee temperatures in an effort to create a safe environment. On its face, the mere scanning of a person's temperature may not run afoul of the biometric privacy laws. However, some of the products that are being used have the ability to capture and collect biometric information, which has caused some concern. So while businesses are implementing some of these procedures with the best of intentions to protect the health and safety of those that work or visit the facilities and businesses, it's important to understand the scope of the biometric privacy laws in the state and where these policies are implemented and ensure that proper steps are taken in terms of continuing compliance. If you have any questions, we're happy to field that. So thank you for today.
Thanks so much, Paul. Next up, we have the co-chair of our Consumer Financial Services Litigation Group, Tanya Esposito.
Great. Thank you so much, Sean, for allowing me to participate today, and thanks for everyone who's listening. As we think about what we expect in terms of regulatory and enforcement actions in 2021 and beyond, it's important that we think about or take a look at the continuing impact of the pandemic on consumers. And so, of course, we all know that in 2020, Congress enacted the CARES Act, which provided relief to consumers in a few different ways, including stimulus funds and mortgage forbearances, which were somewhat limited in the way they were supposed to be applied. And then ultimately, the industry seemingly allowed consumers to have access to those types of forbearance relief plans, regardless of what type of mortgage was in question or was at issue. The CARES Act also amended the Fair Debt Collection Practices Act such that any consumer who took advantage of the mortgage forbearances that were allowed under the CARES Act, that no negative information could be reported in connection with that forbearance. And so subsequently, in March of 2021, Congress passed the American Rescue Plan, and that afforded $10 billion in funding to homeowners. And the applicable funding is essentially attributed or to be used for delinquent mortgage payments, and the states are allowed to sort of figure out the ways in which they'd like to provide those relief payments or help with that issue. But the goal effectively is to stabilize households and to minimize foreclosures and to mitigate any related litigation. But beyond that, the types of litigation and enforcement activity that's anticipated, both in 2021 and beyond, of course, relate to mortgage foreclosures. We are in a moratorium phase where foreclosures and evictions cannot proceed, and we're going to talk more specifically about what's happened on the regulatory front in that regard and how they've been extended momentarily. But we will certainly see a large amount of litigation in connection with foreclosure issues as they relate to consumers as well as evictions. We also anticipate there will be a large number of litigations, and we're actually already starting to see litigations surrounding credit reporting and the Fair Credit Reporting Act, as well as debt collections. Many of the states stepped up during the very beginning of the pandemic and said, you know, we're not going to allow for any debt collection activities or seizure of stimulus funds. Most of that is still in place, and some of it has actually been extended throughout the duration of the national emergency and at least 30 days beyond that point. But we fully expect that there will be lots of litigation around debt collection once those types of moratoriums are lifted. On the bankruptcy front, while we have seen lower numbers than has been expected on individual bankruptcies, that's likely because consumers have been able to access relief funds and have, you know, allowed a lot of consumers to avoid filing for bankruptcy. But as those sort of relief funds run out and a lot of the moratoriums on, you know, foreclosures and debt collections expire, the expectation is that those numbers will rise. Can we move to the next slide, please? So talking a little bit about the regulatory and enforcement outlook, as we all now know, Democrats are in control of the House, the Senate, and the White House, and the Biden-Harris administration is very focused on consumer issues, has been very vocal about making that a priority of their administration. And that's evidenced by the selection of Rohit Chopra as the bureau head, which is pending and has not yet been approved. And he's actually, you know, still sitting as a commissioner at the FTC, but Chopra has a very long track record of being an aggressive consumer advocate. He's often, you know, written dissent opinions that are very clear about his position on how certain consumer issues should be litigated and how the FTC, the CFPB, and any other regulatory body that deals with consumers should be, you know, sort of very proactive and aggressive in their approach. And so the full expectation here in Washington is that will be sort of the continued approach and agenda. And there actually has been some recent CFPB pandemic related activity. You know, there's been a mortgage servicing rule proposal on April 5th, according to which the CFPB would revise Regulation X. And so this rule would seek to enhance the protections for impacted borrowers and amend aspects of the early intervention requirements that the CFPB currently has in place and the loss mitigation procedure. So it would allow for example, incomplete or otherwise inaccurate loss mitigation applications to proceed such that lenders and servicers could afford consumers, you know, allow them to work with their existing mortgage and to modify that mortgage without going through the full-on protocol that had been in place prior to the pandemic, which was a very sort of extensive, lengthy, document-involved process. So the CFPB is proposing, you know, that this would sort of help smooth out that process. And again, the goal is to eliminate or at least lessen the number of foreclosure litigation. But most notably, the proposed rule puts a sweeping hold on commencing any foreclosures until 2022 and actually prohibits a foreclosure referral until after December of 2021. And so that's just one example of the ways in which we see, you know, the CFPB sort of putting, or the current administration putting the CFPB to action here. Similarly, on May 3rd, the CFPB also issued a Fair Debt Collection Practices Act interim final rule, which was an amendment to Reg F. And this rule would require debt collectors to provide written notice to tenants of their rights under the eviction moratorium and prohibits debt collectors from misrepresenting tenants' eligibility for protections from eviction under the moratorium. So effectively, you know, what this rule would do is basically tell debt collectors, if you're in the process of trying to evict a tenant from a property, you absolutely have to make that tenant or consumer aware of the fact that they have rights under the federal laws. They have rights under the FCRA. And if you don't do that, and if you don't follow those steps, you, landlord, owner of this property, can be you know, prosecuted under the FCRA. Let's see, can we move to the next slide, please? Thank you. And finally, it would be remiss to not talk a little bit about fintech. This is a space where the regulatory landscape has been evolving for quite some time, and it continues to evolve. But it's of particular importance at this juncture because consumers took real advantage of fintech platforms and are still taking advantage of fintech platforms and using them more readily during the pandemic, just because they provide expanded and easy access to banking products that would otherwise require, you know, sort of face-to-face interaction. And so, you know, we see consumers accessing these fintech applications to make investments, to, you know, just engage in daily banking, to consider loan opportunities and the like. And beyond that, these fintech applications actually have provided communities of color or otherwise historically underserved or underbanked communities with opportunities to have access to information and to more easily engage with the marketplace. And so as we see this shift and this trend upward and consumers' willingness to engage with these fintech applications, it's appropriate to assume that there will be, you know, a heightened level of awareness and or regulation in this space of all of the sort of issues that arise under a normal brick and mortar, you know, financial services entity that provides banking services to consumers, dealing with privacy, dealing with, you know, truth in lending, dealing with the whole sort of list of alphabet soup of consumer protection statutes that apply to any other form of lending. So it's fully anticipated that we'll start to see the same types of regulatory and enforcement actions, as well as private litigation ensue as it relates to the world of fintech. Thank you so much for having me today.
Thank you, Tanya. Next up is the chair of our Cybersecurity, e-discovery, and privacy group, Scott Carlson.
Thanks, Sean. We can go to the next slide. So I'm going to touch on a handful of cybersecurity issues that I think are important for 2021. Some of them pandemic related, some not. You know, the first, probably most significant trend we're seeing is that ransomware cases have grown at a phenomenal rate this year. The first quarter, some estimates are, and you know, these are tough numbers, you know, because people don't publicly report this stuff, right? So there's no centralized reporting. So it's a little anecdotal, but some estimates are that ransomware is up as much as 60% in the first quarter alone over last year. So it wouldn't surprise me anecdotally when I talk to others in the industry, that's kind of consistent with what everybody's seen. Ransomware's changed. It used to be they just encrypted your data and deprived you of that data, and if you could restore from backup, you were fine. Then it shifted to a combination. Last year, it sort of moved to they would exfiltrate or steal some of your data and then also encrypt it. And the idea was that sometimes they put you on a wall of shame and they would post you on a blog if you didn't pay them, or would otherwise try to entice you to pay because of the ability to leak sensitive business information or personal information, things that could embarrass the organization. Now we're seeing even recently a threat actor that just hopped in the world January this year. They've given up on the ransomware business and they've announced now that they are only going to be in the exfiltration business, and that they think they'll still demand payment, to avoid the public disclosure of the data, but they were moving to a pure data exfiltration world. I don't know that will catch on altogether, but it is a constant change. The amounts of ransoms, refreshingly, the last few I've dealt with in the last month were under 100,000. That's refreshing, oddly enough, because if I looked back in the last year, and most people in the industry were seeing 7-figure and 8-figure, $1 million and $10 million plus ransoms. So to see that some of the marketplace still thinks $100,000 is a lot of money in a ransom is sort of refreshing in a sick sort of way in the line of work I'm in. Another issue, and lawyers it's important in this because OFAC, the Office of Foreign Assets Control, is much more focused, and it did some language to sort of encourage and reiterate that you can't pay people on the sanctions list. So we are seeing more on the anti-money laundering issues as well. So I think the government's a little more involved, but it's a tenuous situation of just how much control are we going to put over the payment of ransoms. But certainly you can't pay a sanctioned party. Email compromise leading to wire fraud is an important issue that also touches the lawyers, because if what happens here is the threat actor will compromise the emails, say, of your finance department, they will then monitor that email, understand your wiring habits, and they may choose to, maybe a customer that normally would wire you money, they will get in the middle of that transaction and say, hey, customer, we changed our wire instructions. So actually wire the money here instead. And they're often successful unless you've got a lot of times human controls on each side to know that, well, wait a minute, the wiring instructions, I'm not going to email and ask about that. I'm going to call them and make sure. So those kind of controls are important to avoid this kind of fraud. And if you do become a victim of it, legally, it's really a conundrum, because your customer paid. So are you going to sue your customer for not paying? They did pay, they just paid the wrong person. Or is it an issue that you didn't have the right security controls in place? You in some ways, I mean, you certainly suffered a loss, but so did the victim, the customer. So the law is quite muddled in who ultimately prevails in that. So you don't want to be involved in it. Employee training remains important. It's still in many ways your first line. While there's a lot more sophisticated attacks going on, employee training remains really important. I want to touch on cyber insurance. To those of you that the cyber insurance market is growing dramatically, I will say that it still remains in a bit of a immature market. It's a newer product. It's not like all of us could sit around from 50 states and talk about whether that hailstorm that hit the house is going to be compensable in our homeowners policy. We'd have a pretty good idea, and it wouldn't vary dramatically in all 50 states. Cybersecurity policies are much, much broader in what they cover, and you have to really pay attention. Some pay ransoms, some don't. Some have different limitations. You need to worry about how they interact with your other policies, crime policies, all sorts of other property policies, business interruption policies. So it becomes a very complex thing that the lawyers need to pay attention to, and more so than ever. We're also seeing a trend this year because of the increase in attacks. We are seeing much stronger underwriting requirements, much deeper questions about, well, what is your security if we're going to take you on as a risk? And we're also seeing that it's increasingly expensive, and a general unwillingness in the market, because it's been hit so hard, and unwillingness in the market to really increase your premiums. The usual threats also continue. The unemployment insurance fraud case came out of the pandemic. There's a lot written about that. I'd refer you to Carpe Datum blog, which is what blog we have called Carpe Datum. And you can read more about that. And then other attacks just continue. So with that, I'll wrap up cybersecurity and move on to e-discovery. So be a little brief.
Thank you, Scott. Go ahead.
Yeah, I'll be a little briefer here on e-discovery. I think what's happening here is a couple of trends. We're kind of moving beyond efficiency, and most of these are really technology driven. What we have is we've kind of moved beyond in cases just the efficiency of getting out your discovery and making sure you can collect it and move it. Now we're much more focused on getting the most out of the discovery. Applying artificial intelligence means applying better analytic models to try to use your discovery in your cases in a way that is much more tactical, and being able to just not respond to discovery, but use it in a much more tactical way. So that's we're seeing because of the improvements in artificial intelligence and some of the tools that we're now seeing in the discovery world. Now, the other downside, though, and that's been great for us to be able to move in that direction, the downside of that is that we're also seeing technology improve and grow the volume and variety of electronically stored information. And this was some pandemic driven as well, right? The people who are working at home, more ways to collaborate. I mean, we've all learned there's a lot of ways to do video conferences, and we've all kind of gotten over that. And we're seeing there's more recording. We're seeing there's more, that the increase in collaboration tools and things make the ESI problem more complicated. So that is an issue we're going to continue to face. And I don't see a slowdown in the change in technology. And so this has sort of brought back the role of the e-discovery attorney being more important, because we've seen this growth in technology, both using it as well as what we have to collect. So with that, I'll turn it back to the moderator.
Thank you, Scott. Next up is Jason Preby. He's in our privacy and cybersecurity group.
So next slide, please. In terms of data privacy and compliance, there's been an increasing trend of information more than ever, also because of just the way the modern economy is going, and it's also pandemic driven, as Scott mentioned. That information about employees, about consumers, about customers is an asset more than ever. This certainly started with the big data trend and data analytics. It's nothing new, but what's changed in terms of privacy regulation and litigation is the dynamic that individuals have rights to their personal information, their private contact or personal data information about their habits, maybe their online shopping or purchases, beyond just social security numbers, credit card numbers, and things that have been regulated for a long time. Those concepts really, as we know, began with the European GDPR concept, but they're coming to the U.S. in different varieties of state regulation and laws, like the biometric law that Paul spoke about earlier. And those concepts of continuing control, accountability by companies for what information they have, and then the technical requirements of getting appropriate permissions, restrictions on the sale or transfer of information, and real teeth on regulatory enforcement are things that are changing, especially in terms of the landscape going forward. And while with the changeover of the new administration, there was, again, like there always is, talk of a federal privacy law that just not come to be just yet. There's still talk about it, but what we have continued to see, what's been grabbing the headlines, are the state level laws. And of course, front and center there is California's CCPA, which in the past year has also been updated for what's to come with the CPRA and the new category of sensitive personal information, in addition to just personal information about consumers. Virginia has also gotten some attention because of their state level law, the PIPA, but there's some differences between Virginia and the California law, which are, some would say, is a little bit more business friendly, including the specific exclusion of employee information from coverage, as well as limits that are not based upon the revenue of a company for the applicability of the law, but on the number, the sheer amount of personal information that a company handles or processes or deals with. There are around 19 states that have other laws either being considered or in committee that relate to the identification and really regulation of consumer information or internet activity information as a category. And that's different from these biometric laws that Paul spoke about as well. So some of those were introduced in states like Illinois just before the pandemic started, and then they sort of have languished or were dropped. Others simply didn't pass it or failed to proceed. And examples of that could be even Florida, which the Florida bill just died just this week because of disagreements among the legislators about the individual cause of action and whether one should be there or not. And one could imagine that some of those legislators were looking at what happened and is continuing to happen in Illinois with the BIPA and litigation that has really mushroomed over 1,100, suits filed, and the concept between whether these laws are there to enhance individual privacy rights or enhance the accounts of plaintiffs' attorneys. In terms of enforcement and litigation, those are still really driven by data breach. So some of the things that Scott just talked about often lead to, in the end, the fines and enforcement, because a company will end up having to send out a notification, and then that's going to cause a blip on the radar screen of a particular regulatory enforcement agency, whether that's HIPAA or a state attorney general that's enforcing something with respect to the state privacy law in a state like Massachusetts, or in Europe on the GDPR stage. Certainly the largest fines have been as a result of companies that had data breach. And then in Europe under GDPR, there's an individual and separate regulatory enforcement and investigation that can be done by the data privacy authorities just really on their own, but certainly most often they're triggered by some kind of a complaint or an event. And in terms of that, domestically, from technical enforcement standpoint, the California AG has been staffed and they have a department, and they have started enforcement activity just over the summer, but also those are mainly, at least for now, either the big data companies that are on the radar screen, or they're driven by consumer complaints or data breaches. And then on the global scale, the European model and GDPR framework has really spread out into other countries, including Central and South America and the APEC countries. Those trends are going to continue from a business standpoint, and if you've got an international footprint, you'll be seeing a lot more inquiries with respect to service providers or locations or even customers in those countries, and making sure that information is protected in compliance with those foreign laws. Thanks.
Thank you, Jason. Up next is Jesse Coleman, our co-chair of our healthcare group, to talk with us about healthcare litigation.
Thank you, Rebecca. Next slide, please. So there are a lot of different types of healthcare litigation that exist, but the largest cluster, undoubtedly, when people think of healthcare litigation, has to do with False Claims Act or FCA claims. FCA claims, as you may know, involve liability for anyone who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval to the U.S. government. This is not exclusive to the healthcare industry, but with the healthcare industry making up nearly 20% of our economy, you can imagine that the healthcare industry is particularly focused on this when you have incredibly large payors such as Medicare and Medicaid at the federal and state governments paying for healthcare, and the move in managed care and value-based medicine. We are also seeing False Claims Act cases involving the knowing failure to disclose material noncompliance. That can also lead to liability. That, in general, is the False Claims Act, but there are a number of statutes under which you can make false claims that are particular to the healthcare industry that we'll talk about. These claims are subject to heightened pleading standards. You have to do the fraud analysis under Federal Rule of Civil Procedure 9b. And there are two primary vehicles by which you can bring, or that False Claims Act cases can be brought. One is a private avenue. It's not specifically a private right of action. It's a government cause of action, but it can be brought by individuals known as QUITAM or QUITAM relators who are able to bring a cause of action on behalf of the government, where they are, if they are successful, able to obtain a substantial portion of the recovery for themselves. They're often looked at as private attorneys general. There is also a government investigation piece to the FCA claims. The key TAM relators will often, they will turn it over to the government, or the government will commence the investigation, and then the government can decide whether or not they continue with the investigation themselves or hand it back to the key TAM relator, at which point the key TAM relator will get an even larger portion if they're successful in obtaining recovery against the defendants or the respondents. The Department of Justice is the primary entity for the U.S. government that enforces the False Claims Act, and there is an entire area of law that's addressing whether or not the DOJ can move to dismiss claims to preserve its prerogatives. But that's a discussion for another time. Looking to the Department of Justice and their stats, if we could look to the next slide, please. We actually see in 2020 the lowest recovery of FCA claims in recent history. Now, this is deceiving, and we're going to talk a bit about why this is deceiving. The decrease, however, is 27% down from the $3.08 billion in fiscal year 2019. It's important to note that this remains primarily healthcare recovery. The cases are 80% of all FCA claims. So you can see that FCA remains primarily a healthcare-related statute, although, of course, there are huge recoveries in other areas. Now, FCA filings, as opposed to recoveries, were up in 2020 to their highest levels. We see 922 new actions, up from 786. Again, these are primarily healthcare-related claims. The vast majority of them are key TAM relator suits, with about 250 of them being government-initiated. So what are we looking at here? We're looking at 2021 and 2022 to be banner years for FCA healthcare-related litigation. What kind of cases did we see in 2020? And I think we'll see here why 2020 had lower recoveries here. Next slide, please. Well, the biggest cases tended to be in the pharma industry. One of the largest was a $591 million recovery that a pharmaceutical company paid out to resolve claims that it paid kickbacks to doctors to induce them to prescribe drugs. The narrative around this was that they had paid speakers to induce the prescribers to write prescriptions, with over $500 million paid to resolve these claims. One of those same companies and another also paid a total of $148 million to resolve claims that they illegally paid patient copays for their own drugs through independent foundations. And the DOJ has come down particularly hard on this issue and sent out notices that these foundations are going to be subject to higher scrutiny. Looking back in fiscal year 2020, looking forward, we see that immediately after fiscal year 2020, we saw a $2.8 billion global resolution for alleged opioid kickbacks. And this came in right in after the deadline for fiscal year 2020. So arguably, this would have been added to the fiscal year 2020 had it happened a bit earlier. And there's a lot of arguments that COVID had slowed down these investigations in particular, such that fiscal year 2020 could have been the largest or one of the largest ever. But of important note for this is the $225 million paid for individuals that were involved in this, that were part of the corporation, which is the largest payment for this amount ever. And we also have $300 million payment promoting for unsafe prescriptions. So these are the primary recoveries that we've seen in 2020 for FCA. Next slide, please. What are some of the anticipated cases? Well, the large pieces here are Stark and anti-kickback cases, but also because of the hundreds of billions of dollars that were spent by the government for CARES Act, there are a number of certifications the healthcare industry players have to make in order to get that money, and that can also result in FCA liabilities. We've also seen some anticipated cases of folks talking about fictitious companies to gain federal funds, fake vaccines, false test results, and substandard equipment for PPE. So to wrap this up, why are we thinking that we're seeing so many filings? Why do we anticipate that 2021 and I would say 2022 are going to be huge years for FCA? Well, we think we've seen a pent-up 2020. The COVID has slowed down this process. We also see with President Joe Biden, who, while he was vice president, FCA recoveries averaged almost $4 billion a year. Vice President Kamala Harris and Secretary Becerra, both attorneys general for the state of California, and they were crusaders in that area under both, specifically under the California False Claims Act statute. And finally, we've got one political party in effective control of the White House and Congress, and we've seen some recent changes in the Stark and anti-kickback laws. So we expect a lot of movement in this area, and with that, I will turn it back over to Rebecca. Thank you.
Thank you, Jesse. Up next, we have, talking about real estate litigation, Mark Johnson, who is our chair of the Real Estate Litigation Group, and his co-chair, Elizabeth Schreiro. Mark? Elizabeth?
Yes. Elizabeth, are you unmuted? This is Mark Johnson. Thanks for joining us. We have seen in 2020 an acceleration of a lot of the pre-COVID trends that were already existing, particularly the rise of e-commerce and the decline of brick and mortar and retail across the industry. There are struggles of developers, owners, and retail tenants. There was a big shift in the condominium versus new apartment rental construction context. And the impact of the pandemic has been to simply increase that. There's been a lot of eviction and foreclosure moratoriums that were rolled out in 2020. And those are starting now to be kind of relaxed. Indeed, we'll get to the commercial landlord-tenant dispute section in a moment, but we've seen a real increase in the number of lawsuits over landlord-tenant failure to pay eviction cases in California, as that area now has rolled back in terms of the moratoriums that were in place, and to a similar degree in New York, those rollbacks began a little bit sooner. But you know, the real estate market is optimistic. There are I do a lot of construction contracts as well. There's a lot of development going on. So between that and the rollback of the moratoriums, that's going to continue to spur real estate litigation. Next slide, please. By far the biggest news from last year, which continues in full force this year as well, is in the area of commercial landlord-tenant disputes. Now that's been due largely to the impact of the government-ordered shutdowns and capacity restrictions that were imposed on tenants. This includes both the retail and restaurant industries, as well as the office lease context. And it's affecting both landlords and tenants. In terms of trends, tenants are arguing that they are relieved of their obligation to pay the full amount of rent set forth in the lease during those temporary periods when they were shut down and unable to conduct normal operations. Certainly, curbside service has affected the dynamic there in that discussion. Some tenants have actually gone so far as to try to launch into the ability to rescind or terminate a lease altogether. Based on the results we've seen, those tenants have largely been unsuccessful. Courts are not going to allow tenants on a typical 10-year commercial lease to have a get-out-of-jail-free card because they were shut down for 2 to 6 months. Listed here on this slide are the typical lease provisions and common law excusability doctrines invoked by the parties. Force majeure, which is French for superior strength, it means something where something overcomes or overwhelms the circumstances, making it impossible for a party to actually perform. Now, landlords, for the most part, embrace force majeure clauses in their lease, and that's because most force majeure clauses contained in commercial leases contain carve-outs for monetary obligations for both parties both landlord and tenant, they're unable to escape that. So if a government order or pandemic or public health concern can be defined as an event of force majeure, the tenant's still going to contractually be obligated to pay rent. This is really where both parties turn first in analyzing these issues to first see if the lease's force majeure clause applies at all. Casualty is another lease provision, sometimes invoked by parties. This has been kind of an iffy defense for tenants so far, primarily because typically casualty is also defined as an event of force majeure. And again, that's not necessarily the tenant's friend in these cases. Frustration of purpose is a common law excusability doctrine, and this is where most tenants have turned. This doctrine excuses performance where a party's principal purpose for entering into the lease is substantially frustrated by an event that it is not at fault for, and it's an event, the non-occurrence of which was a basic assumption of the lease. So here, the dynamic is that the tenant can still technically perform. It can still write the rent check, but the whole purpose of it doing so has now been frustrated, not due to its own fault. Impossibility is another common law doctrine. Impracticability is a different name for it. This is basically the common law equivalent of an event of force majeure. It's been kind of met with limited success for tenants because some courts have noted that landlords aren't suing you because you're not able to operate. They're suing you because you're not paying rent. Co-tenancy is another lease provision that we've actually seen to be a very fertile area for tenants. Under those provisions, they typically identify specific anchor tenants that are required to be open and operating within the shopping center in order for the tenant's obligations to pay full rent under the lease to govern. Where one of those anchor tenants is closed, which a lot were due for the same reasons that retailers were closed, then the amount of rent due is substantially reduced, which is significant because it affects the amount claimed by the landlord. And in those cases where landlords are seeking eviction, it really implicates the validity of the underlying notice of default. In terms of lessons learned, while the contours of excusability defenses and the impact of force majeure are still being developed, preliminary results have shown that the results of courts have been, court opinions have been that they tended to skew in favor of landlords. This is all the more so in the office lease context. There have been some noticeable exceptions recently in favor of tenants and restaurants. Whether or not a cohesive body develops this year remains to be seen, and it may very well likely cause landlord and tenants to be more willing to try to enter into compromises and reach business resolutions by way of lease amendments or modification agreements. Next slide, please.
Can you hear me now, Mark?
Yeah, we sure can, Elizabeth. Go right ahead.
Sure. So in the context of excusability, in addition to some outlier cases that favor restaurant tenants, there was also a case last month in the Eastern District of Michigan where the court found that the purpose of the mattress firm lease involved in that case was temporarily frustrated, which is a kind of novel decision because usually frustration of purpose goes to the entire lease and would terminate the entire lease. And here, the court carved out a rather equitable doctrine, which would excuse the tenant's performance for the duration of the governor's order that caused the shutdown and prevented the tenant from operating. And whether that will take hold and be a decision that is followed across the country remains to be seen. As Tanya mentioned in her talk about consumer finance and so forth, the foreclosure and bankruptcy area of real estate litigation will certainly rise this year as the foreclosure moratoria and so forth are lifted and government assistance runs out. I also mentioned that there are some novel issues that have come up as a result of COVID-19. For example, one court last summer in a commercial hotel foreclosure in New York State, the court said that you have to look at what is reasonable in a UCC foreclosure sale in the context of a pandemic, which may clearly not be the same thing as what is reasonable under normal circumstances. As foreclosures continue to rise, people and entities will be driven to file for bankruptcy. Chapter 5 is now available as an option for smaller reorganizations that are supposed to be more cost effective and streamlined. Bankruptcy decisions on rent obligations during the pendency of a bankruptcy case have been mixed, as in the non-bankruptcy cases in that area, as Mark just discussed. Next slide, please. And there are new areas of potential real estate litigation. Claims against owners and property managers arising from actions taken or not taken during the pandemic, such as alleged improper restrictions or obligations imposed upon parties or alleged inadequate protective measures taken. There also may be insurance coverage litigation arising from such claims. New areas also may come up in real estate contexts, such as cybersecurity claims, claims relating to inaccurate or incomplete disclosure regarding the impact of COVID-19, and claims relating to compliance with legislative mandates for board gender diversity disclosure and lack of diversity. And in closing, I would just mention that if history is our guide, the notion of opportunity existing due to the fallout of COVID-19, plus optimism that we saw in the real estate market from the Seyfarth recent real estate market sentiment survey, will show that real estate litigation will rise, since it's a tool to accomplish these goals in the business context as well as necessity from time to time. Thank you.
Thank you, Mark and Elizabeth. Before we lose folks, so you want to hear Chris, because he's going to talk to us about the trial outlook, and I know everybody wants to know what's going there. The CLE code is SS5839. Again, SS5839. Chris, go.
Boy, I always love speaking after the CLE code is given. So looking forward to 2021, there's actually been some recent guidance issued by the ABA and some other trial and bar associations. And you know, in my 3 minutes here, the real conclusion is we're looking really at what's going to be a hybrid going forward. I think in civil litigation, obviously criminal cases are different. Criminal cases involve constitutional issues. They involve speedy trial issues. They involve different logistical issues. Obviously, the Chauvin trial, went forward. There was some urgency to that, and we are going to see that criminal trials, and we're seeing this in our status conferences. We're seeing this in our discussions with both federal and state judges, that criminal trials are still going to take precedence, and there's a tremendous backlog of non-urgent criminal trials. They're trying to plea them out. We'll just see if they can, but everyone has a right to a jury trial in the criminal system, and so if they demand their jury trial, that is going to continue to create that backlog. And how willing courts will be, and judges will be, and prosecutors will be to plea those cases out at something less than what they might in a pre-pandemic scenario, we just don't know. So where does that leave us on the commercial side? Where it leaves us really is, again, this sort of hybrid 2021 in terms of a combined, some in-person, some remote aspects of trial practice and aspects of court operations. And part of that's geographic. We're already seeing, certain courts start to reinstitute some in-person proceedings in places where, the vaccinations have been ahead, or they've loosened restrictions sooner than some other geographies. But probably the biggest takeaway is a lot of the remote aspects of what we did in 2020 will remain. Many of us at Seyfarth tried remote bench trials in 2020 that were logistically very successful. The judges are getting more used to it. The witnesses and the lawyers are getting more used to it. And so we are seeing a lot more use of remote technology to do hearings, to do presentation of evidence and witnesses. Already, the AAA, the American Arbitration Association, already had rules that allowed for completely remote proceedings. So they really didn't look at COVID as a significant difference from what they had done in the past. The courts will need to adjust because there were emergency rules and emergency legislation put in place to allow for more remote hearings and trials, and whether those will continue or not is going to be up to those legislatures in those states and the federal, obviously the rulemaking bodies within the federal system will have to determine that as well. And lastly, with my last minute, I think remote mediations, this is just me, are here to stay. The idea of packing, your client, lawyers, everybody into an airplane to fly somewhere to sit in a conference room all day while the judge spends most of the time, at least most of our clients perceive this, in the other room, beating up on the other side. That probably is something we're not going to see nearly as much. And almost all of the main mediation outlets, that we work with have had and continue to expand and develop that remote capabilities. And personally and statistically, the statistics will come in, there does not appear to be a significant change in the resolution rate of mediations, whether they were live or remote. Roughly the same, based on the statistics that are coming out from 2020, roughly the same number of cases are settling as were settling in the pre-pandemic. And I'm at 2:01, so I'll leave it at that, but obviously happy to respond to any questions from anyone after this program is over. Thank you.
Excellent. And just one more time, the CLE code is SS5839. Sean?
Thank you for everybody for coming. We have written materials you can find on our website, or if you want a shiny hard copy of the brochure in terms of our Outlook 2021. And thank you very much for joining us.